Bon lundi.
Good, happy Monday to all. I call the meeting open to order. Meeting number 122 of the Standing Committee of Industry and Technology. Today's meeting is in hybrid format pursuant to the standing orders. Now, to avoid audio incidents, I'd like to indicate that before we begin, I'd remind you of all the other participants in the room of the following measures. To prevent disruption and perhaps harmful audio feedback incidents that could cause injuries, all persons in the room are reminded to keep their earpieces away from all microphones at all times. As indicated in a communique from the Speaker to all members on Monday, April the 29th, the following measures have been taken. All earpieces have been replaced by a model which greatly reduces the probability of audio feedback. They are colored black, whereas the former were gray. Please use a black approved earpiece only. By default, all unused earpieces will be unplugged at the start of a meeting. When you're not using your earpiece, place it face down on the middle of the sticker for this purpose. As indicated, please consult the cards on the table for guidelines to prevent audio feedback incidents. And of course, the room layout has been adjusted, as you've obviously seen, to increase the distances between microphones and reduce the chances of feedback from an ambient earpiece. The measures are in place so that we conduct our business without interruption and to protect the health and safety of all participants, including your interpreters. We thank you all for your cooperation, and which brings us to today's meeting. A new week, a new day, and another session on this bill. Pursuant to the order of reference of Monday, April the 24th, the committee is resuming consideration of Bill C-27, Act to enact the Consumer Privacy Protection Act, Personal Information and Data Protection Tribunal Act, and Artificial Intelligence and Data Act. And I'd like to thank the witnesses that are appearing today. Industry, in virtual capacity, Mark Sean, Senior Assistant Deputy Minister, Sami Chabra, Director General, Marketplace, and Runa Agnes, both in person here. Before beginning, and hopefully to avoid confusion,
We're still on CPC 7, and there is a sub-amendment by the bloc that's on the floor right now, which we were debating. So I will go to perhaps Mr. Garon pour son sous-amendement.
Oui, Monsieur le Président.
Well, thank you very much, Chair. When I last spoke, we were on CP7, and we tabled a sub-amendment which was under discussion at the time. We've had some discussion towards the end of our meeting last week, and what we'd like to include in the list of points in the definition of sensitive nature. I've proposed and I've sent to everybody my copy of the sub-amendment. I'd like to have unanimous consent. I can read it if you like. Well, to withdraw the sub-amendment, which do we have the unanimous consent so that he can withdraw the sub-amendment that we had previously discussed? You're presenting a new one today, right, to replace the last one. Do you want me to do it right now? Sure. Well, if you allow, thank you very much. Then we'll know what we're talking about. So do we have unanimous consent to withdraw the prior sub-amendment? Okay. Mr. Garon, you still have the floor to introduce your new sub-amendment. Well, thank you, and thank you, colleagues, for your generosity in allowing unanimous consent. It would read as possible. I'm going to do it in French, but the interpreter will do his best. The motion, CP7, proposing amendment clause of 2 in Bill 37, after line 33 in page 5, to amend it by sensitive in relation to information includes any information about an individual for which The individual generally has a high expectation of privacy, which includes but is not limited to A. Racial or ethnic origin, B. Political opinions, religions, philosophical beliefs, trade union or political membership, or political contribution previously made, sexual orientation or sexual habits, and D. Genetic data or biometric data that could uniquely identify them. First, his health condition, including any treatment prescription to medical record, government identifiers such as a SIN number, security, passport, or driver's license numbers, and G is to the financial data. Now, I think it might be appropriate that I make a few explanations on this. First, there was the possibility of introducing it by way of a list in the text of the law. They were not too enthused about that, but within the amendment, there is a list which doesn't really take the form of a list. So we've done it by proposing a list using alpha, A, B, C, D, E. And we felt that there were two issues here. First, the context. I think it was Mr. Shan, among others, that we have to be careful of what sensitive information is. On the first line, we indicate that the individual has generally a high expectation of privacy, which isn't exactly the same definition as what was proposed by the Supreme Court decision. Eventually, there may be another interpretation by the Commissioner and by the courts. We know that the model right now, state of the art, is a European principle and policy. What really gets us is biometric data or genetic data. This concerns us more than anything else. Biometric or genetic data cannot be masked once they're been gathered, if you will. So we find it's absolutely essential that they be considered as sensitive material. We also included trade union membership, which is in fact perhaps goes well with political membership. And again, it's in keeping with the European practice. The officials were discussing the possibility or the issue of sexual identity or sexual orientation or habits. Now, this could lead to some forms of discrimination, and the European Union also considers that this type of data is sensitive and should be treated as such, private. Now, the economy didn't stop because these are conditions that have to be respected in Europe. Now, in the EU, financial information is considered severely or supremely sensitive information in the matter of financial data. I've contacted my European colleagues. The bank system is still solid, sound. There are interbank transactions that can occur, and all that information does not identify an individual, and when it's transferred, it does not have a huge impact on the breach of privacy issues. There's international conventions on the exchange of information, financial and banking data. We have no anticipation that we'd get any personal data in there. I thought it was pretty hard to swallow that the banks would collapse if they didn't get this information, but personal information. Pretty soon, I think there's going to be a possibility of open banking. While you can't impose federal laws on Desjardins, but the exchange of information will be framed or contained by the protocol on open banking, such that in the context of privacy protection, it will be deemed sensitive information. We're open to discussion, of course, on this, but you shouldn't remark and note. We tried to deal it so that everybody would feel that they could agree to it by consensus. Well, thank you. On the motion, I have Mr. Massé and Mr. Albast.
To make sure I have this, what is the, and maybe I may need some discussion with the researchers, trade union or just union? So that pops out because trade union, it might be a translation issue because trade union often is like the building trades or an additional layer of skilled trades that could be different than other unions. So I'm just curious about that change. And then the lacking of personal information, so I'm just not sure whether we need the word personal in there or not, but that's the one big difference. But I appreciate this constructive approach to trying to find a way forward, but those were the two things that I'm curious about to get specifics on.
Merci, Monsieur Massé. Écoutez, c'est une question qui
Thank you, Mr. Massé.
note that in the original form of CPC 7, that was the language, but maybe is that a question for Mr. Chan or?
Yeah, perhaps, but of course, Mr. Garon, of course, I'm always interested to hear his response in case he's done other research, but to both, actually, quite frankly.
So, Monsieur Chan, peut-être ensuite Monsieur Garon? Ou?
En fait, l'esprit, c'était d'inclure l'appartenance.
Well, union, it's a translation error in the text, actually. So, trade unions, labor unions, etc. In the case of any doubts, the French version shall serve as the correct one.
So I don't know if it should be labor union or trade union, but we're maybe I don't know if Mr. Chan, you have a word to say. So you've unmuted yourself.
Seulement pour ajouter, Monsieur le Président.
Certainly, Mr. Chair. In Canadian context, the laws that deal with the origins of any union is Trade Unions Act. That's the framework legislation.
Incorporating statute for unions is the Trade Unions Act, but I wouldn't have the specificity as to whether or not using trade unions would somehow rule out other unions, but certainly the Trade Unions Act extends well beyond the building trades.
Merci beaucoup, Monsieur Chan. Donc, je pense que ça clarifie.
Thank you very much, Mr. Chan. That clarifies the issue for me, at least. Mr. Albast, Turnbull, and others to follow.
Sit on the Joint Standing Committee for Scrutiny of Regulations, so I always keep a key eye between French and English translations, so I was hoping the officials could clarify the last sentence, qui comprend notamment et sans limite, et la même chose comme
which includes
to. Is that essentially the same thing? And then I do have a follow-up question for Mr. Garon.
Monsieur le Président, je passe la parole à mes...
Well, I think I'll leave it to my colleagues to see if they can distinguish the difference between the two.
Je pense que le mot notamment fait l'affaire, donc notamment.
Well, I think that's acceptable. Includes, but is not limited to.
Eventually see this at the scrutiny of regs where we have to quibble over whether or not it is. In regards to this, Mr. Chair, just ask Mr. Garon, referring to something that has not yet been identified is always a bit of a tricky thing. So when you say that is equal expectation of privacy but not limited to, what kinds of things could this be referring to? Because again, we are counting on an interpretation of future bureaucrats and obviously the minister responsible to be able to determine what would have that status. So I'm always a little loath, particularly after the C-22 debacle, of giving too much power of interpretation to future decisions without clarity as to what we're giving consent to.
D'abord, on inclut une liste et deuxièmement,
Well, first, we have a list, and we say not limited to, because had we adopted this act 10 years ago, biometric information wouldn't even figure in the list. We didn't have that kind of data. Supreme Court said it was reasonable intrusion into privacy, and we are saying quite specifically high expectation of privacy. So the courts may decide to grant that it should be included, but it would allow, in principle, the courts to interpret the notion of high expectation of privacy and extend the list if necessary. But it won't change the regulatory authority of the minister.
It's been done here, and obviously I'm not a regular member, so I'm not going to comment about it because this may have come up before. But this is why we have usually 5 or 10 year reviews written into legislation, because I would much rather, if there are other subjects that are deemed important 5 or 10 years from now, I'd like it to actually originate from parliamentarians' review of things. That keeps the ball in the Parliament's court rather than someone who's making a recommendation and a minister who may have a much different value system than some of the parliamentarians that are elected to that parliament. So that being said, thank you, Mr. Chair, and I appreciate Mr. Garon's interventions today.
Thank you, Mr. Albus. And the 5 to 10 year reviews are a lofty ideal that isn't always respected, I would say, and Mr. Massey could attest to it, but a nice ideal indeed. Mr. Turnbull, the floor is yours.
Thanks, Chair. And I want to thank Mr. Garon for, again, I think putting something forward that attempts to combine numerous points that other parties had been making in the debate to find a path forward here. I appreciate that. I appreciate Mr. Massey's willingness to allow some of his thinking to be incorporated into an amendment, which is great as well.
Just 1 second, Mr. Turnbull. Monsieur Garon.
je veux dire qu'on n'a pas d'interprétation en français.
Okay. Il semblerait qu'il n'y a pas d'interprétation. Je veux juste...
C'est revenu. C'était possible de...
Okay, Mr. Turnbull, if you can start from the top.
Oh, I was just expressing my appreciation for your work, Mr. Garon. Is that coming through okay? Yeah. And also for Mr. Massey allowing you to incorporate some of his thinking into the amendment that or the sub-amendment that you've proposed, which is great. Sounds like we're off to a constructive start here. I do have a couple of questions. One of the questions that debates we got into last time was around financial data. I know you've included it in your list. Intuitively, I kind of go, yeah, financial data seems like it would be sensitive information. But I think both the Privacy Commissioner and the Supreme Court disagree with that. They've said that the degree of sensitivity of specific financial information is a contextual determination. I could go on and quote them, but the Supreme Court decision RBC versus Trang in 2016, has stated explicitly that in not all cases is financial information actually deemed sensitive, or that the degree of sensitivity differs depending on the context of its use. So maybe I can go to Mr. Sean just to back me up on this, so you're not taking my word for it. The experts and officials are here with us for a good reason. Mr. Sean, can you just add anything to what I've said?
Yeah, thanks so much for the question, Mr. Chair. So as relates to financial data, I'll start and then I'll turn to my colleagues to talk a little bit about the treatment of financial data and information under the GDPR, because I know that was raised as a contrasting issue. It's important to note that our system is somewhat unique in the sense of once an information or piece of personal information is deemed to be sensitive, it requires express consent. And it's not just express consent for its collection, it's express consent for its collection, use, and disclosure, which means that it's the express consent that's required for its actual kind of initial gathering from an individual, and then for its ongoing use, and then when it needs to be disclosed to a party that is not the party who collected it, including in the process of business practices, that express consent is required. And so financial data and financial information is an extremely wide category. It includes transaction data. It includes information related to whether or not you hold more than one mortgage. It relates to a whole host of information that essentially is personal information that ties you to any type of financial transaction, of which there are many. And so this would essentially require express consent for every single collection, use, and disclosure of that information. And so, an example being, if I've, have an ongoing payment history with my bank, and they need to use a third-party processor, as many do, for the purposes of continuing to use the transaction data, that would require express consent at every single one of those disclosures along the chain. So not just when I first sign up for my bank account or even make the transaction, it actually then is going to be required at every single step of the way. And so it is quite a broad category. I think it's important to note the distinction between this express consent obligation and the varieties of ways in which processing and data information processing is allowed under the GDPR. And so for that, I'll turn to my colleagues who can further enunciate a little bit about why it hasn't gummed up the EU system, in part because it's not understood in the same way. So over to my colleagues.
So I'll take the question on the GDPR. So in the GDPR refers not to sensitive information, but to special categories of personal data. And under those special categories, that's Article 9 of the GDPR. It refers to racial or ethnic origin, political opinions, religious or philosophical beliefs, or trade union membership, the processing of genetic data, biometric data for the purpose of uniquely identifying a natural person, data concerning health, or data concerning a person's sex life or sexual orientation. So those are the categories in GDPR. So as Mr. Sean said, financial data is not actually in the list of sensitive information for GDPR.
Thank you for that. So help me understand. We kind of went through this last time, but I guess what I'm asking myself is, well, so what? Why shouldn't we? Mr. Garon might say, well, or somebody else might say, well, financial information is really important. We want it to be protected. The financial system isn't going to come to its knees and be completely in ruin if we were to pass this particular sub-amendment. But I'm actually kind of want to push back a little bit on that and say, well, what would be the implications for the everyday average citizen that is relying potentially on those third parties and that financial information to be transferred in a way that doesn't present an imposition on the services that they use and consume on a regular basis. So can someone illustrate for me, Mr. Sean, maybe I'll turn to you and you can redirect to someone else on your team if you think need be, but help us understand the actual impact of this. I mean, you've kind of already said to some degree disclosure would be required every single time, express consent would be required every single point along the chain of disclosure. But can you give us more detail on how this might actually impact everyday citizens?
Yeah, thank you, Mr. Chair, for the question. Maybe to go back to first principles a little bit, one of the things that's important to note is that PIPEDA and one of the things that will transfer over to the Consumer Privacy Protection Act is an accountability principle, which is to note that collectors, users, and disclosures of data are accountable throughout the entirety of the life course of that personal information that they've collected for its ongoing use, and are subject to the rules of PIPEDA as a function of those continued disclosures. And so it's one of the ways in which we ensure that in a data value chain that there is actual accountability throughout. And so So it is important to note that there is quite a degree of responsibility placed on those who use, collect, and disclose personal information already. What sensitive will do, as I noted, is require express consent, notwithstanding that accountability principle. And so across the value chain, there is a huge amount of data transfers that actually happen and disclosures that happen between entities that are not necessarily the same entity that actually did the first collection. And so, you know, we've talked about banking, but even in the course of a retailer or others, there are often a significant number of people. So your bank is using a third party like Interact, for instance, and then needs to transfer that information back to the host financial institution. If you used a credit card, for instance, that actually also has a third party payment processor that often is also involved before it actually gets to your bank for the purposes of payment, and then it needs to be disclosed again to the original retailer for the purposes of the clearing. And so in just, you know, buying an apple at the grocery store, you potentially might actually see, you know, 6 or 7 disclosures of the personal information related to financial information, each of which would require express consent of the individual just for the payment and clearing of that one transaction. And so it becomes, you know, quite a lot when one imagines the broad category of financial data and the fact that we're now going to require express consent for every single kind of step along the value chain, as opposed to relying on both the accountability provisions of the CPPA and PIPEDA and the rules that are associated with the use of personal information more generally.
Yeah, I mean, I know we made this point in the last meeting that we had, which was that just because personal information doesn't all qualify as sensitive information doesn't mean it isn't still protected and held to a very high standard, and the CPPA is designed to do so. Obviously, that part of the bill hasn't been contemplated before the committee yet because it comes later. We're still on the definitions, so certainly we haven't got into that, so it may not be as present in people's minds. But I think your point is well taken, Mr. Sean, that the accountability principle is already baked into this bill. Let me ask you also, is financial information transfer already overseen by the Privacy Commissioner as well? Is there ways in which the Privacy Commissioner already has a role to play in overseeing that?
So I'll turn to my colleagues, but just to say all of the provisions of the Act as it relates to personal information and its usage are overseen by the Privacy Commissioner, subject to complaint and potentially subject to remedy. But I'll turn to my colleagues to just be more specific about the powers that the Privacy Commissioner has over the use of personal information, not just sensitive information.
So the privacy, as Mr. Sean just said, the Privacy Commissioner has oversight over all collection, disclosure, and use of personal information. That would include sensitive information, and it would include obviously financial data as well. What the commissioner does is he does a contextual analysis. So information that's not sensitive in one context may be sensitive in another context. Information together may become sensitive where individual categories are not sensitive. So that's how the Privacy Commissioner looks at personal information, determines whether it's sensitive or not, and requires, you know, obligations that are commensurate with the sensitivity of the information. So it does absolutely look at financial information, and there are many cases where they have said that it's financial information. There are cases where financial information is sensitive, and there are cases where they've said, no, it's in this context, it's not sensitive.
By including all financial data as sensitive information, which is what this sub-amendment would do in the bill, that removes the Privacy Commissioner's discretion and ability to issue guidance and to use context as a way of determining sensitivity of that financial data. Is that correct?
Yes.
Okay. So I see the answer was yes, but the microphone wasn't turned on. And then just to go back quickly, so the GDPR categories that Ms. Angus read out did not include some of the things that are included in the list that Mr. Garon has presented here in his sub-amendment. So if I'm not mistaken, it only included up to E, so A, B, C, D, and E, if I'm not mistaken. So if we're really trying for interoperability and using the EU GDPR as our sort of standard, and that's part of the argument, then essentially we would be eliminating F, G, and H, which I think when I read it, those were the things that seemed to carry some pretty high potentially unintended consequences. So could we just verify that the GDPR includes A, B, C, D, E, but not F, G, and H, if I could? And if I'm wrong, please feel free to correct me if I'm wrong. Yeah.
And I'm happy to start and then turn to my colleagues. But essentially, you're right. There are some worrying or considerations that should be brought to bear on some of the pieces of F, G, and H. As we spoke about at last meeting, for instance, it's specifically been noted by the Privacy Commissioner that at least in 2 provinces, driver license information is not actually deemed to be personal information. And it's important to segregate here the driver's license, because that's not what this amendment says, versus the driver's license number, which is what is specified. Because there's lots of personal information on our driver's license, for sure, but what's actually being requested here to be considered sensitive is the driver's license number, which is in 2 provinces already been deemed by the Privacy Commissioner to not be personal information. And so therefore, giving it sensitive information actually not only heightens that, but actually requires express consent. As it relates to we've already been over passwords, or so we've already been over financial data, but passwords is also one that often does have context that potentially should be considered. And so with that, I would just turn over to my colleagues to maybe further elucidate some of the issues in the back end of the list.
Thanks very much for the question. As Mr. Sean pointed out, the context dependency of any analysis of sensitivity of the information is critical. It's a cornerstone of the OPC's submission to this committee, is that we start with a context analysis of disclosure, collection use or disclosure of any information. And that's really important because while there might be some scenarios where it is somewhat rare for a category to be considered sensitive or not sensitive, that contextual piece is what really gives the Commissioner the ability to ensure that privacy is being protected at the highest level. In the case of UGDPR, as Mr. Sean already pointed out, financial data is not included in Quebec Law 25, nor is it included in the EU or UK GDPR. Similarly, the aspect of passwords is not included in any other jurisdictions, save for California, where it's referenced in a very specific manner, which is that your login information for a sensitive use case would therefore then be considered sensitive information, because it's what the password and the user credentials give access to. That's the nature of the sensitivity there. The inclusion of passwords overall, of course, as we explained at the last time we spoke at the committee, was simply that it also introduces a degree of non-neutrality in dealing with technologies that could also be problematic in some cases. And as Mr. Sean already pointed out, driver's licenses have been specifically ruled not to be personal information by the OPC in 2 provinces. So adding the designation of sensitive personal information is something that the OPC himself has said is not personal information at all, would be somewhat of a conflict.
I'll just perhaps add a technical point is the amendment also refers to social security information as sensitive, and social security is not something that's sort of recognized in the Canadian system. It might be social insurance numbers, for example, that have been recognized by the OPC on many occasions as sensitive, but social security is not really a concept that exists in Canadian law.
And similarly, the passport number, I assume that it says, the way it's structured here, the language, government identifiers such as their social security passport or driver's license numbers. So it's really only referring to the numbers. So is a passport number, like, same argument for driver's license. I assume passports have lots of personal information in them that would be, should have a high bar. But the actual number of the passport, is that really, it seems that that's the intention here. I guess, does the same argument that you made, Mr. Sean, for driver's license numbers, also apply to passport numbers?
So, like Mr. Chabra noted in the California instance, that some of this is about what they are being used for. So, and what it actually reveals. So, in the case of Ontario, for instance, for those of us who are citizens of this province, my birth date is included as part of my driver's license number. It's actually the last 6 digits of my driver's license. But that's not the case in a number of other provinces. And so this is, again, where context will matter. In many instances, because of what you can use a passport number for, potentially, and the link back to the individual, in many of those instances, it would probably be deemed to be personal information worth protecting. But by and of itself, it doesn't necessarily suggest that this combination of numbers and letters is necessarily sensitive information, because again, it's what it's for. So I think giving broad ambit to the commissioner to lay out guidance and to actually provide the guidance around what can and cannot be done with this type of information and what protections need to be put around it, including, for instance, maybe suggesting that express consent is actually, the best approach in some of these contexts. That's actually what's more important than just the broad categorization, because again, within that categorization are uses or contexts or, in fact, instances where it's not even necessarily personal information in and of itself.
So, I mean, really, by including these in here, we're saying context doesn't matter. When, in terms of determining sensitivity, we're saying context doesn't matter. Forget context. It's always sensitive information. That's really the heart of the problem, as I see it, with some of the things that may not always be deemed sensitive. And if the Supreme Court of Canada is saying that financial information is not always sensitive, perhaps we should listen to that. So just to clarify, last point here, F, G, and H, so Social Security, passport, driver's license numbers, passwords, and financial data are not deemed sensitive in the GDPR or Quebec Law 25. Is that correct?
That is correct.
Thank you.
Merci beaucoup, Monsieur Turnbull. J'ai Monsieur Viss, suivi de Monsieur.
Mr. Viss, Williams, Garon, and further, Omar.
I'm actually very much enjoying this, I think, really relevant debate. Going back to Royal Bank of Canada versus Trang 2016, Mr. Chair, Mr. Shan, can you please clarify, was that case ultimately about express consent or implied consent in respect to the sharing of information included in one's mortgage?
I'll turn to Ms. Angus to answer that question.
So that case was specifically about mortgage discharge statement and whether two banks could share that mortgage discharge statement with each other. And what the Supreme Court decided is that they could, because it wasn't sensitive information in that case.
But to my question, was it about an individual in their relationship with the bank having express consent to share that information, or did it establish a scenario of implied consent?
I'll have to look at that and get back to you, because the main crux in that case was specifically about the sensitivity of that information.
Right. So the way I understand that court case right now is Trang defaulted on their mortgage. They go to another bank and they're saying, no, we can't share this information. It's sensitive. And then the Supreme Court ruled, well, you actually had implied consent when you signed with the bank and provided your personal information. Therefore, the sensitivity of your in the context of the sensitivity of the information in respect to your mortgage is it's allowed for the banks to have access to that information because you provided implied consent when you signed up and got money from the bank in the first place. So I state that because I ultimately believe the argument being made by the department right now is factually incorrect. To state that to buy an apple, you would have to provide express consent, I think is undermining a complete commercial relationship that exists already between every banking customer in Canada and banks that exist. And frankly, I think it's a bit of an irresponsible argument that's not well backed up. So just another. I'll make that point right there, and I say that in the most respect because the interpretation bulletin on sensitive information Sorry, what's that, Mr. Turnbull?
I said it didn't sound respectful, but that's okay.
Okay. Thank you for your opinion.
Yeah, no problem.
Under the interpretation, financial information is sensitive information. Financial information is one of the types of private information that falls at the heart of a person's biographical core. However, the degree of sensitivity of specific financial information is a contextual determination. My understanding is, if based on the Privacy Commissioner's interpretation, you can still list information as being sensitive and allow for a contextual argument to be made in the operationalization of the law. So what the department's saying right now is they're basically predetermining the application and operationalization of sensitive information with the Apple context that was provided today. And I just think that's a little over the top because we have well-defined processes in Canada between every banking customer and the bank, which allows for sensitive information to be treated wisely. And I just don't see the basis of that. And in addition to the nature of the Supreme Court ruling, which was about implied consent. So I guess I'll ask another question. In freedom of information in Canada, is financial information deemed to be sensitive or not? Under the Freedom of Information Act.
So under the Access to Information Act?
The Access to Information Act, Section 20.
I'll have to refer to my colleagues, but maybe just quickly to go back to the previous point, there is no reading in of context in the proposed sub-amendment. So it is a determinative list. It specifically states that sensitive information is this list. There is no paragraph that indicates which, due to the context of its collection, use, or disclosure, for instance, which is what appears in a couple of the other versions of this. So there is no context, and it is all financial information. So it doesn't matter whether or not previously it would have been collected under implied consent or utilized thereafter with implied consent, because essentially by making it sensitive, we've required that it has express consent, and it has express consent across every single aspect of the value chain.
Well, to point back, I'll just to push back, the Privacy Commissioner says, however, the degree of sensitivity of specific financial information is a contextual information. He's stating there that financial information is sensitive, but it's also contextual. That's the point I'm trying to make, Mr. Shan.
But in the sub-amendment that you created, you're actually altering the rules upon which he has the ability to interpret that. So there is no context. He's
state the whole thing about the applicability. We could state the whole thing about the applicability of PIPEDA in the context of a brand new piece of legislation. Maybe the subcourts are going to rule a completely different, make a completely different determination because we're having a whole brand new law. We haven't even got into a debate about that in the application of some of the previous rulings the Privacy Commissioner's made, and by extension, maybe the Supreme Court one day.
But just to continue to highlight why the context, the Commissioner is only able to interpret that which is within the law. And right now, some of the proposals include a specific reference to context. This proposal does not. This proposal lists a set of information, decrees them sensitive, and because of other parts of the law, decrees that sensitive information requires express consent.
What other parts of the law? Or bill, sorry, what other parts of the bill?
The parts of the bill that we'll actually get to, hopefully, which lay out what the rules related to sensitive information are, including around consent, which is where it will state that sensitive information, at least in Kurt's version, says that sensitive information requires express consent.
Can you just point me to that section? I want to read it right now, please.
I'm happy to add to that, Mr. Chair, on behalf of Mr. Sean. So sensitive information is referenced in the bill in section definitions 2 sub 2 in the Privacy Management Program 9 sub 2 under the Appropriate Purposes Clause. Section is, so starting with definitions, it's section 2 sub 2. A Privacy Management Program, section 9 sub 2. In the Appropriate Purposes area, 12 sub 2. Under consent, which is 15 sub 5, under prospective business transaction, which is 22(1)(b)(2), under completed business transaction, which is 22(3)(a)(2), Under retention and disposal of personal information, which is 53 sub 2. Under security safeguards, which is 57 sub 1.
Maybe Mr. Chabra, what specific section that would apply to the Apple example?
Well, thanks for the question, Mr. Chair. I think the point Mr. Sean was trying to make and the point we were trying to raise earlier is that
What section would the Apple, in the current bill, where would the interpretation of sensitive information be applied?
So the interpretation of sensitive information, of course, will be applied to all of these sections, but
I just want the specific.
So specifically,
number.
It would be consent. I think, if I understand your example correctly,
The department's example.
Sure. So I think it's 15 sub 5, which
15
speaks to
sub 5,
consent.
thank you.
I think the point that the member was raising earlier was about how would this impact the practice. And I believe if I understood the example or reference made correctly, it was that there's already an existing payment system that would manage these issues. But of course, the point that the department is trying to raise here is that that payments processing system is predicated on our system of laws, including PPADA. In other words, that PPADA, in the way that it's currently constructed, and the CPPA in the way that it was proposed to be put forward, enables these existing systems and processes where they are appropriate and lawful and rely on appropriate uses of consent. The point that I think Mr. Sean was raising earlier was that if we modify the definition of sensitive information in the way that's been proposed under the BQ sub-amendment that the committee is considering right now, it would obviate the ability for those payment processing systems to rely on the current approaches that they use today. And that's why it's particularly critical that we get the definition of sensitive information right. And I would refer the committee back to the OPC's formulation or preferred formulation on this, which is to start with a reference to it depends on context. The context of the collection, use, or disclosure is critical. And that following that, we could put forward a list that is not exhaustive or exclusive, that gives an indication of the types of zones we're talking about. The current formulation of the BQ sub-amendment does not provide for the contextual analysis, nor does it provide any space around considerations of what's on the list. It is, as Mr. Sean already pointed out, a firm and final listing.
One, I would say it says, but may not be limited to.
But what's on the list remains part of the list.
In other words, the list itself is final. It could be added to, but what about the stuff that's on the list? It means that the way that's currently constructed, I think our point is that it must be sensitive no matter the context.
Okay. Well, actually, going back to page 12 of the bill on form of consent, I think it ultimately makes the point that I'm trying to make, that we can have sensitive information and still allow for a contextual analysis even though information is deemed sensitive. And under form of consent on page 12, it says consent must be expressly obtained unless subject to subsection 6. It is appropriate to rely on an individual's implied consent. And I'm stating that in the context of the Supreme Court ruling, which has been referenced in the last two meetings, which was specifically about implied consent, taking into account the reasonable expectations of the individual, which we haven't discussed. We've taken a very black and white reading of what sensitive information would be, and the sensitivity of the personal information that is to be collected, used, or disclosed. So later on in the bill, what I'm reading is that there is a reasonable expectation built into information that even could be deemed sensitive, and its commercial applicability.
Thank you again for the question. I appreciate it. Your reference to sub 15 sub 5 is where we're looking at too, and it says it's the reasonable expectation of the individual and of the sensitivity of the information. Both of those have to be considered in that scenario in order to consider.
Exactly.
And so when you say and the sensitivity, and by definition you've constructed a bill that says that this information is always sensitive, you've then obviated the ability to take advantage of implied consent. You've now defaulted to a scenario of express consent. And that's the issue that we're raising for consideration.
Okay. I'm going to give that some thought.
In other words, the test for the use of implied consent requires two subordinate tests to be met: the reasonable expectations and the sensitivity of the information. So if we're automatically raising some information, some personal information, to the level of sensitive information at all times, it doesn't allow for this contextual analysis to occur.
I don't completely agree with you based on the interpretation bulletin from the Privacy Commissioner, but I'm going to leave it there. But just going back to my other question on freedom of information, it's my understanding that when in that legislation in Canada, that all information is deemed sensitive. There's other contexts in Canadian. The point I'm trying to make is that there's other contexts where financial information is deemed to be sensitive. Here, man, at our own committee, we've had to review contracts of over $50 billion this year alone on Stellantis, North Star, Volkswagen, and all of the arguments made about why the public shouldn't have access to that information is because it was a sensitive information of the corporations. So. That's in the context in which I'm approaching this, and I know that's an example outside of the law, but it was really frustrating as an MP that we only had 2 hours with the contract. That was $15 billion. Anyways, I digress. Mr. Chabra, that was very helpful analysis. I still disagree, but you made a good point. Thank you.
Merci, Monsieur Vice. Je passerai maintenant la parole à Monsieur Williams.
Mr. Williams, you have the floor.
I agree. This has been a good discussion all around. I think when we have to go back and back this up a little bit, when we look at the difference between personal information and sensitive information, the difference with sensitive information is that the potential harm or discrimination is greater. And what we're listing with this is we're ensuring that when we use these examples, there's extra layer of protection when we're looking at these examples. I'm one of the ones who disagree with not having financial data on there. I think there's a higher degree of identity theft and fraud. Same with driver's license. Increasingly, through and through, we're seeing that Canadians are under threat of having their identity stolen. And as technology gets better, as we see Canadians find that they're using more apps or more technology, they're finding that their privacy is under threat. And I think listing these items as sensitive, especially when we see increased vulnerability from Canadians, is really important. First question, Mr. Shen, where are we using sensitive in this bill as a whole? When we're talking about sensitive information, where are we using it generally?
So I'll start and then I'll turn to Mr. Chabra. But as Mr. Chabra noted, sensitive comes up in a number of places of the bill, the most important of which is what you can't rely on as a use of information if the information is deemed sensitive, which is the example he just went through with Member Viss, which is that because we've cited a two-part test essentially for things like implied consent, you can't rely on implied consent if the information is deemed sensitive, which means it requires express consent. So again, just to go back to last week's kind of discussion, that's not to suggest that things like your driver's license number or your personal information of a financial nature have zero protections. They actually have considerable protections, and actually by allowing for the guidance making powers of the OPC to opine on these issues, you can get to effective oversight of those informations without necessarily suggesting that in every instance they require express consent, which is the most important part of what happens when you deem something to be sensitive. And so I'll turn to Mr. Chabra just to lay out again where sensitive comes up in the bill.
Sorry, just one more context, Mr. Chabra, when you're answering. We do use the words generally when we're identifying sensitive. So would the legalese for generally not imply that it's requiring an offer, acceptance, or consideration without putting too much emphasis? Are there ways that generally used in this context also allow a little bit more flexibility?
Thank you very much for the question. I would agree that the way it's formulated is intended to rely on the context-based assessment that would be undertaken. So when you say something would generally be considered sensitive, you're giving an indication of direction, you're setting a policy frame or parameter that allows for interpretation to occur effectively. What is being contemplated before the committee now is to lock in a definition of sensitivity in the definition section and then attempt to rely on, well, it's generally sensitive. Well, that becomes a law that's full of ambiguity and becomes very difficult to interpret and apply. It's not what the OPC has asked for, which is to have a context-specific determination with an indication potentially of some areas that could be considered sensitive. To your earlier question, 17 times sensitive information is referenced in the Act. I'm happy to kind of reference each, if that would be helpful.
Well, I think my point on that is it does seem, if we are, and it's not in the definition, but it is implied that this is a greater potential harm of discrimination or I guess of harm to individuals. When we've looked at this whole bill from the onset, it's not yet in the purpose statement that, privacy is a fundamental right. We look around the corner. I'm looking to add an amendment. I'm going to add one piece that isn't in here, but I think is really important given when we look around the corner to where technology is going to be in the next 10 years or so, which is location data. So when we look at that piece of information, location data is everything we have in our phones and our watches, in our cars that identifies who we are, where we are. Going backwards on that, we look at financial data, it also is evolving. We have open banking in front of the government right now. We've been pushing for that. Open banking is really ensuring that customers have control of their financial data on their consent. That's very much the wording of how we've listed that. Customers then have control of that. If it's not sensitive data, then what are we doing with that consent and how we're giving it? I think it's a form of control for Canadians and for people that when we're looking at privacy as a fundamental right, it is listed most of these times on your consent. You can move your information to there. If your data is being recorded and tracked, it has to be under your consent. That to me then, on its very nature, when it comes to harm or discrimination, is sensitive. We can then further in the bill, because we're only in the definition side of this, we can further in the bill then take that context and debate how that's used or what's going to happen. But I don't think we should then be taking that out of what we deem to be sensitive. So if we go to the potential for harm or discrimination, obviously we're looking at extra layer protection for security PIAs. But, I think we're really, as a committee, just defining information that is exceedingly being used in identity theft, in fraud, in stigmatization, and discrimination. I think all we're doing is listing that as something that we want to protect. And I think what we've been trying to identify are those. So, Mr. Chair, I'm going to read, I'm just going to talk about it first, but I'm going to have, he's gone. I'm going to have an amendment to add I, which would be location data. And I'll just read why that's important really quick here. Location data is considered sensitive for several reasons. We have personal security and safety. Location data can reveal where a person lives, works, and frequently travels.
Point of
order.
Compromise. Sorry to interrupt you, Mr. Williams.
I don't think we have a chair to point of order you. Yes. We can take a recess, Mr. Chair. What is the soup today?
I was inspired by Mr. Perkins, Mr. Turnbull, on the point of order.
Yeah, I just wanted to check whether you could introduce an amendment to a sub-amendment. I don't think you can, so Mr. Williams, I think, is sub-amending or sub-amending something, which I don't think is procedurally correct.
That is correct, Mr. Turnbull. You can't sub-amend, or you can't amend a sub-amendment. So we are debating right now a sub-amendment, so you can't amend the sub-amendment. But Mr. Williams, perhaps, should this sub-amendment by Mr. Garon be passed, then you could amend the amended amendment.
Okay, then I will summarize this. I'm not making the amendment now, but in relation to my argument about sensitive data, location data is certainly an addition. But going back to my original argument on this, I think when it comes to what we're looking at for consent, this is not the section in which to debate that. I think we're debating what is sensitive data, what can be used for potential harm or discrimination, what needs an extra layer of protection. And certainly I think the items that have been listed are all part of that, and I believe that Mr. Garon's sub-amendment is a good one. Thank you.
Merci beaucoup, Monsieur Williams.
Thank you very much, Mr. Massé, then Mr. Garon, followed by Perkins, if we have time.
I think it's important. I think we're at a kind of an impasse in terms of a philosophical argument here, more than technical with regards to the bill. For myself, the use of data and the system in place financial institutions currently employ is inefficient to the economy. It certainly is at the disadvantage of the consumer, and that's one of the things I'm looking to change with this bill. Especially with you have, and Mr. Williams actually, I joked about like the auto when he mentioned some of the location issues that he's referenced is actually very astute in that, because the value of automobiles in the future will be as much as it is about gathering information than it is actually them producing, manufacturing, and distributing it back into society. It's actually going to be the value of the consumer that needs to have some choice. And so this actually rights, I think, in a social injustice that we have, and also an economic dependence model when it comes to financial institutions that puts basically consumers and small businesses and medium-sized businesses at disadvantages in our economy. Like, it's pretty abhorrent that we still have some of the information that's gathered right now from credit cards that's routinely distributed and is sold for information that gains that financial institution leverage to use against its own customers. So what I see with regards to this amendment, where I'm siding at this point in time, is actually to strengthen that path forward, so people have a calculated ability to use their information to quantize that, even economically if they want, by consent. And I think some of the fear things that are coming out there is that, if you do anything in your phone, you're going to be crippled because we went ahead with this type of an amendment. But whereas it can be is quantified so that if you, for example, want to sell or give access to your information in an empowerment model, then it can actually be for reduced fees, costs, or financial incentives that could be granted to you through the changed system of information here. So I don't really have a question at this point in time. I mean, I'm not sure how far the government wants to continue to go down this road if they don't have the support from other parties with their particular position. And I understand where it comes from, and I understand some of the arguments that have been made, but it really comes to determination of how long they want to actually prolong this bill and prolong this process, because I'm not moving off the spot. It's a definite, benefit to the social and working class to actually have empowerment models for their financial information and otherwise. And it's up to businesses to come forward with a model that works for them, but actually it comes at the expense of being better supports for their consumers and also supporting their customers. So where we go at this point, I'm not sure. I think it's a philosophical impasse at the moment, and we can continue to have more questions and comments and so forth. I'd like to see the privacy component of this bill move fast, but at the same time, I'm looking for a philosophical change, and that's where the NDP is at this moment, is using the leverage that we have at this point in time and opportunity to turn the financial institutions back to where they should have been historically, is actually serving the customers. And information is everything coming up in this day and age, so having more opportunities to leverage that opportunity for the working class is what we should be doing here, because the fees, the costs, and also the financial way that this country has been endorsing these policies is very inefficient for productivity. And I'll conclude with that, because it's very important to understand that our money management system and our information system are very much tied to the hip, and why we would undermine consumers or individuals to exercise their rights in this would be a mistake.
Merci, Monsieur Garon, suivi de Monsieur Turnbull.
Merci, Monsieur le Président. Écoutez, je pense.
Thank you, Chair. I think that we've had a fulsome discussion here. Much has been said on the sub-amendment. If the government doesn't want this sub-amendment, they don't want our financial information, which is quite sensitive, be subjected to some form of consent. I find that's regrettable. But we don't know who the minister consulted before tabling this bill, which has quite a few amendments, and because perhaps it was badly drafted to begin with. Which banks, which financial institutions, which assurance company, perhaps consumer groups, we don't know. Now, from those who defend this bill, this amendment was drafted so that properly worded that the individual has a high expectation of privacy. So the commissioner, the OPC, could take a look at the context, and there's no limitation on what he can do by way of analysis. Bill 25 in Quebec protects certain categories of financial information and data, but the majority of banks, the majors, are regulated by federal statute. I conclude that financial information is extremely sensitive information. I'll repeat that. I recognize that financial information is highly sensitive. This was in the decision of the court, Supreme Court, where certain contexts, certain transactions, consent is implied, implicit. But the amendment doesn't read that financial information are always sensitive. But generally speaking, when circumstances are that there a high expectation of privacy. That's the spirit of this motion here. I agree with my colleague, Mr. Mossett. To not include financial information would be a step back from the current position. So I'd like to maintain my position and come back to the comments of my colleague, Mr. Williams, that the list is not limited to. So, well, you said cars. That's an excellent example. If the individual has a general expectation, a high expectation of privacy, so be it. The 5-year reviews or 10-year review, as you said, it's not a sure thing. You know, the 5-year review sometimes occurs at the 8th year, but I think we have to go ahead with this amendment. You know, you might get consent fatigue. We're told that individuals will be completely exhausted from consenting. So under that psychological situation, we should let the banks decide, or we would include the financial information of an individual, which includes sensitive information. I have no doubt that the technical formulation of the phrasing and the wording, but I took a look at scientific information as to fatigue, consentment fatigue. That's what it is. That's what I read, that it is a fatigue. So people will be so exhausted from consenting. And on the Apple Watch that Mr. Turnbull is wearing, he'd get an alert every 5 minutes when a bank or someone is seeking consent. No, the Ministry Department Industry, they get communications. People are afraid that their information will be available, will be out in the open. Cell phones, for example, contain massive amounts of private data. So we want, you know, maybe your average consumer, I've never heard a consumer say, look, when you do legislate, please don't continue to exhaust us. Okay, I have Mr. Turnbull on my list.
Look, I'm hearing out all of the colleagues here. I just, I really feel like this is going to impact, you know, have a negative impact. And I think that the officials have said to us that numerous times now when I've asked them questions that this sub-amendment deems everything on that list, even though you can add to the list, but everything on that list would be deemed sensitive and therefore require express consent every time the data is collected, used, or disclosed, right? So just imagine the impact that that might have. Now, this is not to argue against the points that have been made here ideologically. Yes, I agree. All of the information is important information that needs to be protected and should come with some pretty stringent requirements. But that's part of the construction of this bill, as I understand it. That doesn't mean that every single piece of personal data should be deemed sensitive. And I know that's a bit of an overstatement, that everything on this list, I think we've argued numerous times that this list includes things that are not in the EU GDPR. I have the EU GDPR right here, so I'll give you the very specific information that's included in it. And I'm surprised when members are arguing that this list here is included in the GDPR, and it's not, as far as I can tell. When I type in what personal data is considered sensitive in the EU GDPR, it lists personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data processed solely to identify a human being, health-related data, and data concerning a person's sex life or sexual orientation. That's it. So I want to understand, and I also understand from asking officials that this is not, the list that's here is the F, G, and H, and Mr. Williams wants to add I, which is location data, if we ever get to that point. I would argue again, would put us out of alignment with both the EU and Quebec's Law 25. Can I clarify that, Mr. Sean? And just get you to state that again. Would that be the case that we would be out of alignment if we had all of F, G, and H, if they're included successfully and this sub-amendment gets passed, that will put us out of alignment. In other words, Canada would have a law that is more stringent than Quebec when it comes to deeming personal information sensitive. Is that not correct?
By the drafting of the list currently, and it's in including these broad concepts, yes, it would extend well beyond what is currently deemed sensitive under both Quebec's law and under the GDPR.
Yeah, and just so again, the impact of that, would this harm commerce in the country, for example? Like, would this actually have a really harmful impact on the general sort of flow of commerce? Like, we walk into grocery stores, we buy things, we use our Interact cards all over the place. What impact would this have on the average Canadians? Because I actually think it would have a pretty significant impact.
So, and I'll let my colleagues weigh in as well, but the value chain for the processing of financial information in particular is a multi-staged value chain. It involves multiple players and outside of the initial collector, because there are people in the value chain for financial services that do very different things. So there's the initial payments kind of transaction point of sale kind of piece that potentially requires and collects the initial information that then needs to continue along the value chain to ultimately allow the funds to come out of your bank account and get paid to the people who are supposed to receive them. And so by suggesting that this is generally sensitive information, it will require express consent, which means that you need to expressly consent for every single step along that value chain, because each one of those is considered a disclosure. And so I think that at minimum upends a significant amount of current business processes, but second of all, will create a significant amount of responsibility on the individual to be able to allow for the movement of their financial data, to allow for the continued fulfillment of their economic needs. So I'll turn to the team to see whether or not they want to add anything.
Yeah, maybe just briefly to echo what Mr. Sean has said and amplify a bit. Can think about it in terms of the impacts that it would have on commerce on a day-to-day basis. You can certainly also think about it in the context of interoperability of systems. A big discussion at this committee over several different meetings has been about the degree to which Canadian businesses are incentivized, the degree to which the competition framework drives innovation and delivery of new and effective services, the degree to which our systems are able to attract investment. I believe committee members this morning have referenced open banking or consumer-driven banking, which is an ecosystem that relies entirely on data-driven innovation and to create these new competitors and to shake up kind of the legacy systems. So in that context, certainly having a different rule set or approach to sensitivity of information could have an impact on the degree of investment attraction, the new services and offerings that are developed and put on the market. And so again, it's an important piece to consider whether there's actually significant enough value add from adding financial data to outweigh those other considerations.
Right. So, and is this what the OPC has asked for? Because it sounded to me like the Privacy Commissioner is not asking for this particular approach. The Privacy Commissioner wants some categories of sensitive information to be identified, but to be able to use their discretion and identify context or consider context in terms of identifying how sensitive certain information, personal information is. Is that not correct? Yeah. So what would the OPC, the Privacy Commissioner, say about this particular sub-amendment if he were here today?
Just before we get to an answer, Mr. Turnbull, I'd appreciate if colleagues, if you have discussions, you wait until the end of the meeting or you ask for the chair to suspend the meeting. But out of respect, please, I'd ask for everyone to listen to the discussion we're having. It's an important one. Mr. Shan.
So I'll turn to my colleagues, but I think the commissioner has indicated in previous kind of fora that he believes it's important that we have a definition of sensitive, that it lists out the types of categories that are likely to be sensitive, but that it includes context in the collection, use, or disclosure that will allow for that context to be laid out through his guidance. And the categories that he's listed do not include those that are currently in F through I. But I'll turn to my colleagues just to further confirm that.
Thank you for that. The commissioner has been clear about the interest in having a context-based definition as the foundation for any definition that the committee chooses to adopt here. I also think it's worth pointing out that, of course, the commissioner has issued guidance on this issue several times, including, I think, most recently in 2022. And for greater certainty about what we're talking about here, it should be really clear that not including something in this list as part of the definition certainly does not obviate the commissioner's ability to include it and to provide a much more detailed context-based definition or parameters around what would make certain types of information sensitive in a given context, including many types of financial information, which could also be included via OPC guidance. The issue, I think, that's before the committee right now is about whether the unintended impacts that could occur by listing an item here strictly in the definition would be worth the effort to do so. And what I think the consideration is, what does that offer over and above what the commissioner is able to do via guidance?
Mr. Garon has said that potentially consent fatigue is not really a thing, or that perhaps I actually think that if we make this sub-amendment, it will become a thing. It'll become a much bigger issue for the average Canadian. I certainly, trust that the systems we have in place are protecting, and I understand that sometimes they break down. Sometimes there's breaches of privacy, and those are things that the Privacy Commissioner will be able to deal with. Maybe, is there aspects of this bill that we haven't contemplated yet that really can assure members of this committee when dealing with certain types of information that are included in F, G, and H, that those are actually protected but not necessarily always deemed sensitive? Because I think that's the heart of the issue for me. I hear ideological arguments about wanting to protect information that members want to deem sensitive to ensure that those are held close and really protected. And I get the desire to do that. I get the motivation behind that. There's a good motivation behind that. I get that. But think about the ramifications or the unintended consequences of that when not being able to consider context. I think that's really the issue, but also that the bill itself is designing a framework to ensure that F, G, and H are still come with requirements that are significantly robust and perhaps more robust than in the past. So, Mr. Sean, can you speak to that? Because I feel like this is the missing piece here, is that we're stuck in a definition and we're trying to do something in the definition that the rest of the bill will deal with in due course, but we haven't gotten there yet. So members of the committee may, and I don't mean this in a disparaging way at all, but we're not there yet in the bill, right? We haven't looked ahead and necessarily gotten to that point. So, Mr. Sean, can you give us some detail on how the bill in later phases or stages really raises the bar and the requirements for personal information that suggests that not all of it needs to be deemed sensitive in order for it to be protected?
That's right. So the overall structure of the Consumer Privacy Protection Act makes significant improvements to the existing Personal Information and Protection of Electronic Documents Act in the treatment of both personal information generally as well as sensitive information. So some of what would be wrapped up in requiring express consent at this point will be further contemplated, for instance, in what are the obligations for the general protection of personal information. So what sorts of privacy program do you need to have in place to be able to ensure that you've done things like ensure that you've got effective controls, that you've got effective, have you left yourself vulnerable to cyber risk or other sorts of aspects, for instance. Those are the sorts of things that will get covered in a privacy program. There'll also be further considerations about what it takes and when you are allowed to make a disclosure. So when am I allowed to move financial data, for instance, from one payments processor to another, and what are the kind of guardrails around that? And so there will be, as contemplated in the Act, a very high standard set for the treatment of personal information writ large, including in a number of the instances that would get wrapped up in what's currently contemplated as kind of trying to do through sensitive information. But by making it sensitive, we are expressly requiring its express consent, and therefore taking away the flexibility of the context-specific reading that the Privacy Commissioner has asked for, and then also kind of suggested that all of those other things that will come later that protect that information, aren't doing anything when in fact they very much will. I don't know if my colleagues want to weigh in.
Yeah, I'm sort of looking for the specific section that deals with personal information and the requirements around that would perhaps reassure committee members. And I'm struggling to find that in my binder, but I know I've read it and I could definitely find it.
I'll turn to the team who can point to some sections that would have treatment of personal information and the important guardrails around it.
Thank you for the question. As I mentioned earlier, there are 17 times where sensitive information is specifically listed, including in 15 sub 5 where it talks about forms of consent. It also appears under retention and disposal of personal information, which is 53 sub 2. Again, under security safeguards, 57 sub 1. Security safeguards, again, 58 8A. It's really throughout the entire Act, and if we're looking for areas of the Act that speak to the responsibilities and accountabilities of data holders, it is really quite well spread out. My colleague might have a few other references for you.
I think we have to remember that when we talk about personal information writ large, so just not about sensitive information, all the obligations, whether it's about security safeguards, whether it's about retention and disposal, as my colleague said, are applied to all personal information. It's the degree that changes. And with respect to any personal information, there is obviously the appropriate purpose. So you can't collect, use, or disclose any personal information unless you have an appropriate purpose for doing so. And that's an obligation that applies to all personal information, not just sensitive personal information. So you can't use information just because you want to, and that's an obligation that applies in all contexts.
Okay, thank you. And I know the members opposite have mentioned open banking. What impact will this sub-amendment have on open banking? It seems to me like it would have a pretty big impact on the possibility of moving forward with an open banking kind of system.
So I'll start, and then my colleagues will likely want to weigh in. But as noted, because financial data will now be deemed sensitive information, consumer-directed financing, as it's understood, relies on the data portability obligations that are found within later sections of the CPPA, which would have a consumer direct one service provider to provide their information to another service provider. But that doesn't obviate or shift away the kind of realities of the financial services sector that then would follow. So that new fintech player potentially is actually probably more reliant than others on third-party processors or other kind of aspects, because they've kind of made their niche in one aspect of financial innovation, which is potentially providing services. But that doesn't mean that they're going to be having the whole back end that would normally be accompanied by a larger financial services provider. So every single one of those disclosures will require the express consent of their client, which means that when they want to provide a seamless financial services environment for their client, they will be going back to their client on numerous occasions to re-seek their consent for the continued disclosure of the financial information. Mr. Chhabra, or I don't know if Samir or Runa want to weigh in.
Thank you. I'll simply add to that having had the opportunity to speak to some of the experts in the open banking or consumer-driven banking space in recent days, I'm comfortable sharing that they're considering specific issues related to consent, authorization, and authentication, which are each kind of different steps in the value chain that all need to be appropriately managed for different purposes within the consumer-driven banking system. By insisting that all financial data becomes sensitive information, it does change the calibration of the work that's undergoing there. I think it'd be entirely reasonable to say that it's likely to slow down the advancement of the work that's currently being contemplated, and that there's an important distinction to be made between express consent when sensitive personal information is being managed, or whether there's elements that, while still being designated as personal information, may not attract the level of sensitivity given the context of the use or disclosure that's being made to enable open banking, which in some cases is about transferring information to enable services to be provided. So I think the point here is that it's a bit like an iceberg. We need to understand that there's express consent that's visible and available to all of us as consumers in the system, but there's also a lot of work that needs to go on in the plumbing, if you will, to share data that wouldn't be sensitive given the context, in order to enable the provision of those services that we see at the consumer level.
Is some financial information always sensitive? Like, is there an argument, and I'm sort of playing devil's advocate here, so is there some portion of all financial information that should always be deemed sensitive? Because if not, then really this is really problematic. It's even more problematic than I initially thought. But certainly, is there a way to determine financial information, a category of it that would be always deemed sensitive without considering context? Or does context always matter? I know that's a difficult question, but I thought I'd put it to officials anyway to see.
I mean, I think there's a whole lot of financial data that many of us would be uncomfortable seeing shared outside of those that we knew or understood. So, but context does matter. If I said, "Are you okay with me knowing about how much you have left on your mortgage, or how much your monthly mortgage payment is?" You'd probably not necessarily want a wide body of people necessarily to know that. But if I told you that that paying your mortgage when you send that transfer, either automatically or maybe you actually have to manually do it through your electronic banking app, that was going to pass through 6 different processors to ultimately then move from the part of the bank that has your savings account to the part of the bank that holds your mortgage, assuming that's even within the same financial institution. If I told you that that was going to pass through 6 or 8 hands, and I said, that's probably pretty sensitive. Do you want to make sure that you know about every single one of those? And I think if people knew that those disclosures were managed by a privacy program where there needed to be a clear rationale for why that information was being shared, that the original collector was still ultimately accountable for its treatment and for its privacy obligations throughout the entirety of the value chain, I think many people would say, I'm comfortable. I don't want to say yes 8 times. I actually do want that information just to flow. And so I think it's what makes it so tricky to say in all instances this information is always sensitive, because in many cases it's not sensitive within a given context.
So I think if I were to summarize what you said, is that context always matters with regards to financial data. Is that not the underlying point that you've made with your example?
I think that's fair.
So would seamless financial services environment that you described be kind of the thing of the past if this sub-amendment passes?
I think the business processes that I understand are currently in operation in the financial services sector have multiple players within, requiring multiple disclosures per every transaction. And if each one of those disclosures is subject to express consent, I would say that that will be a very different financial services experience than that which we have currently.
I'm glad to hear you didn't use the Apple example. I noticed that triggered my colleague, Mr. Viss, earlier. But yeah, well, thanks for the clarifications. We appreciate it.
Merci beaucoup, Monsieur Turnbull. J'ai Monsieur Perkins.
Thank you, Mr. Chair, and thank you, officials. Before I ask a couple of my questions on this, which I don't believe I've talked to yet, I note that this is the 3rd meeting we've had on CPC 7, third meeting, most of which has been driven by the government's desire to amend and change. I just note that just only because the government suggested all a clause by clause would take 4 meetings, and the government's the one that's pushing this one to take longer. But Mr. Shen, I'm a little concerned at your testimony earlier about the Privacy Commissioner, because C11, which was the predecessor to this bill and the attempt at the Privacy Act changes in the last Parliament, I'd like to read from the Privacy Commissioner's submission to that committee, if I could. While the OPC and the courts have provided some interpretations of sensitive information, it would be preferable to have a legislative definition that sets out a general principle and is context-specific, followed by an explicitly non-exhaustive list of examples, such as those included in Article 9 of the GDPR. This would provide greater certainty for organizations and consumers as the interpretation of the term. For instance, such a definition might read, sensitive information means personal information for which an individual has heightened expectation of privacy and for which collection, use, and disclosure creates a heightened risk of harm to the individual. This may include, but is not limited to, sound familiar? MP Garand's amendment. This may include, but not be limited to, information revealing racial or ethnic origin, gender identity, sexual orientation, political opinions, or religious or philosophical beliefs, genetic information, biometric information for the purpose of uniquely identifying an individual, financial information, information concerning health, or information revealing an individual's geolocation. That was the last bill, so it comes as a surprise to me, Mr. Shen, that you said that the Privacy Commissioner has not asked for that, because it's right in his brief.
So, Mr. Perkins, I would note that C11 was contemplated by a previous Privacy Commissioner.
Oh, okay. So that it doesn't matter then that the Office of the Privacy Commissioner said that. So let me go forward then. Are you aware of the California privacy law?
Yes, I am.
And you're aware that the clauses that in particular irritate the government are actually in that law.
I'll turn to Mr. Chabra to talk about the California consideration.
Thanks very much for the question. I think it's really important to point out that the testimony being referenced speaks to the interest of having an example provided in the definition. And I just want to make it clear that what we're reacting to in front of us in terms of the amendment does not provide examples. It doesn't say may include, for example. It says includes. And so that's entirely different than offering a context-dependent definition followed by some indicative examples. So in that way, it's completely different than what we're contemplating here.
Tell you as a guy who worked for 5 years at the head office of a Canadian bank and sat in focus group meetings with individuals and customers, that there were many customers who don't even share their information with their spouse. So believe me, financial and health are amongst the most sensitive informations, and people want that protection. In addition, are you aware that in the United States, there is the American Data and Privacy Protection Act going through Congress, which does exactly this? And it's a bipartisan bill.
So again, I think that I'll turn to Mr. Chabra, and just to note the fundamental aspects that we've tried to draw out over the course of the discussion today. One is the importance of some sort of context-specific interpretation tool at the outset of the list, which is something that would read like, due to the context of its collection, use, or disclosure, an individual has a high expectation of privacy and may include, and again, this is, so one aspect is context. The second is whether or not it deems to, by definition, include all component members of that class of information, or whether or not it's indicative. And those are two very important points that we're getting at. And I think in the current formulation, there is not that same understanding of the context of its collection, use, or disclosure, and the list is can be added to, but is definitive in its contents.
Has the California law and the GDPR law meant that every time somebody goes to use a debit card, they're required to provide permission?
As noted, the GDPR does not include financial data as sensitive information.
And they have more population than all of Canada. Are they going and asking every time they use a debit card for permission?
Mr. Chabra may be able to speak to the specific formulation of the California ruling.
So California does include financial information as sensitive information, but whether that means when you use a debit card, you need express consent. I mean, it's you using the debit card, so I don't think. I mean, by using the debit card, you're consenting to it. Yeah.
So I think our previous point was about the processing of that information, and I don't know the formulation of the California law well enough to know whether or not it also includes an obligation for express consent and whether or not disclosures are wrapped up in that.
So the current privacy commissioner, Mr. Chan, in the appendix to his submission on Bill C-27, also asked for a list.
He notes the importance of context, and he notes an indicative list.
Oh, the government believes that the right of a large financial institution, as an example, to use your personal financial information in a way that isn't considered sensitive is the side that it wants to go on, not the protection of the individual's privacy and requirement for permission, which they can get as a blank permission. It's not a difficult thing. We all give blanket permissions for privacy when we subscribe to banking services on terms of use of data.
Mr. Chair, I would be uncomfortable with that characterization. I would suggest that the government is suggesting that the definition of sensitive information should have important flexibilities to both understand context and to understand cases and use cases where that information may not be sensitive. I would note that we are not suggesting that the personal information protections afforded to non-sensitive personal information should ever result in someone's violation of privacy or affect their fundamental right to privacy. I think that's comparing two very different things.
So I'd argue by the time this bill passes, we're already at a step with California, and we'll be at a step with the United States, given where they're going with regard to the American Data Privacy and Protection Act. But that's it for my questions, Mr. Chair.
Merci beaucoup, Monsieur Perkins. J'ai Monsieur.
Thanks, Mr. Perkins, Monsieur Généreux, then Mr. Williams.
While we're debating these issues, of course, there's a Telenouvelle article that appeared about a leak. And in that article, there's been 225% instances of breaches of data in the last few months. So the NDP colleague was talking about cars, automobiles, and the information that is collected. I have a 2009, and I'm keeping it because nobody can track my coming and going. Now, were we to vote in favor of this sub-amendment or amendment to CP7 within the bill, Mr. Trumbull fears that this would be accepted, and then we'll have to give our consent each and every transaction and every step on the process and the value chain. The requirements of the bill is also includes its regulations, does it not, in order to avoid that particular complexity or multiplication, redundancy of consent giving, as it were. Well, in regards to regulation, this includes sensitive information as well, covers that. And it is the point of interpretation for that information. But, Mr. Shamma, that doesn't necessarily mean that for the implementation of the bill, let's assume, for the sake of argument, that they'll be containing most of these amendments. I mean, the original drafting, it seems to be quite riddled with errors. It still leaves potentially room for an interpretation. Now, the implementation of whatever is included in the bill will be done so by way of regulation after the fact and the coming into effect of the new law. True? Well, we can't exactly judge how these lists right now are non-inclusive, but all the elements that we want to see are there. There's not much distinction between the two. It's very, very clear. If it's not, if it doesn't come under regulatory control in the bill currently, well, that's the reason why we feel it's important to offer OPC the flexibility to deal with context as well on the list of these and give us an indicative example. You'd probably you would not like to have a CPC 7 at all then. No, we're quite comfortable with the list, but the list is got to be inclusive.
Indicative in both aspects, not exclusive, so can be more than what's on the list, and also within the list that it's indicative, thereby giving the context to the Office of the Privacy Commissioner to indicate the contexts in which it would and would not be understood to be sensitive.
Okay, merci, Monsieur.
Merci, Monsieur Généreux. Monsieur Williams.
Thank you, Mr. Généreux. Mr. Williams.
I wanted to touch on the financial aspects that we've been talking about, specifically open banking. strong data protection actually is a selling point for open banking. That's why we've looked at it for Canada. And it's allowing better data protection technology to come into effect. At the same time, and I've spent, I know Mr. Shabra, you've spent some time talking to open banking. I've talked thousands of hours talking to these individuals, trying to push forward, specifically because they believe that the API and the framework that's going to be developed is actually going to make them more competitive against standard banks in the whole process. And we've seen that in Australia and the UK. You know, I think I just wanted to just get, because I know you indicated you already talked to some of these groups. I'm still unclear as to how listing the financial data as sensitive is going to hurt our financial institutions in Canada, where I think they're going to strengthen them. If there is increased consumer protection and technology that will protect that data, and if we in Canada are ensuring that consumers of Canadian technology and in Canada are going to have a greater protection of that data, I'm not sure why would we see that as a disadvantage, specifically when we're right now, and the only thing that's been produced in the budget is to grant a framework for open banking around the consultation, more consultation on the industry. But why would, when we're developing an API that's going to be used across the whole spectrum in open banking, why would this put our open banking system and framework at a disadvantage over other countries?
So it's about disclosures. It's about the nature of requiring express consent for every use and collection and disclosure of financial information, because the list as constructed says that information is by definition sensitive, which means it cannot rely on implied consent. And so therefore, in the processing of financial information, which often transfers out of one collector into the hands of another as part of an accountability chain, that will require the express consent of the individual. And so each one of those puts at disadvantage the notion of a convenient framework that tries to preserve consent for that where it is most important, which is when the information is potentially at great risk of privacy, and also where that information potentially is not understood in the capacity of the individual to be being transferred as part of the service they're receiving.
Okay, this will be the last comment, and I think we should hopefully get to a vote here shortly on this. But you know, I think what that framework does, and when you look at the financial sector in open banking, it allows customers to explicitly grant or revoke consent and third-party access easier than any other framework we've had in the past. Open banking should be the example of why we're including financial data as sensitive, why Canada wants to protect that data explicitly. And I think the second part I'll just leave, we've included generally as that word that gives, I think, that flexibility to the Privacy Commissioner to then deem what of that financial data and the sensitivity of that should be then, and what context that should be used in. So I think we've given all of that, and I think we've gone around the room on this quite heavily. Thank you, Mr. Chair.
Merci beaucoup, Monsieur Massé.
Thank you, Mr. Chair. I want to get on the record, I guess, some of the differences that we have here. Here we're talking about empowerment of consumers with regards to information, but at the same time we have a government that has not moved on Crown copyright since 1911. So for those that aren't familiar with Crown copyright, it was firstly brought to Canada in 1909, and it was amended in 1911. And what that means, really important to businesses and educators and general society, is that all the information that the government has is basically suspended or not provided to the public, which is different than our U.S. counterparts, different than the Commonwealth nations. And I find it difficult for the government here wanting to continue to have that control of publicly manufactured and basically expensed information under their control when the United States doesn't do this, Great Britain doesn't do this, the Commonwealth nations haven't done this. So I'm just going to ask Mr. Shan, with regards to Crown copyright, what equivalent country is there out there with regards to this? Because the argument is being made here that the government is actually wanting to defeat this amendment that allows the public to have information and control. At the same time, this government continues to block Crown copyright renewal, which is actually providing information to the general public that they've actually paid for. So where in the world is there a consistency of Crown copyright?
Thanks, Mr. Chair, for the question. As it relates to the government's position on Crown copyright, I think it's not a singular position. I think it's important to look at the Treasury Board guidance as it relates to the publicity of information that's generated by the Crown, including the open by default standard and the importance of ensuring that information is actually openly shared. And that there are a number of particular uses of copyrighted information on the Crown side that need to be understood in their full context.
Is there a country you can think of that has a similar regime to ours? Can you give us an example of another country?
I'm not sufficiently familiar on this hearing today, Mr. Chair, on the privacy bill about the full international examples on Crown copyright.
Yeah, no, and I appreciate that. I mean, it is a little bit, but it goes back to the importance of why information is deemed valuable, and at the time we still don't have any comparable. So I'll leave it there. But my point being is that I find it highly ironic that the government values its information manufactured through public expenses that would actually be very beneficial to businesses and other academia and research, and because they have control of that information, and not releasing it is something that's, you know, even the former parliamentary secretary for the Liberals here at this position, former Solicitor General, was much more open to and was actually pro reforming of Crown copyright. But we know what happened with that situation. Thank you, Mr. Chair.
Thank you, Mr. Massey. I have MP Van Bynen and MP Turnbull.
Thank you, Mr. Chair. It seems to me that the concern here is around privacy of information and the sensitivity of information. And so, Mr. Shen, if you could just clarify for me, what type of protections are contained in this legislation that addresses the privacy of information?
Thanks so much, Mr. Chair, for the question. So the overall intent, and there are a number of provisions we have yet to get to in the CPPA that heighten the level of overall privacy protection for all personal information collected, used, and disclosed by corporate entities in the Canadian context. That includes requirements for express consent in a number of areas, as well as limitations on when and how other forms of consent can be relied upon. It also puts in place a very significant enforcement regime over the uses of both those exceptions as well as the privacy protection programs that need to be in place. So the scrutiny of, for instance, the security measures that a company must put in place to ensure that they're not actually exposed to breaches or vulnerabilities, the enforcement of exceptions, where an exception to consent, if it's relied upon, would be, if it's found by the Privacy Commissioner to not have been reasonable, moves it into an unlawful usage of personal information, which means that it's subject to the most significant fines under the administrative monetary penalties regime. And so a very robust overall approach to the treatment of personal information, of which sensitive information is a subset that has a heightened level of privacy protections, but the one that's particularly most important for this conversation is express consent.
That there are certain obligations that are required to maintain privacy. Could you expand on that, please, and what those implications are in relation to what's being discussed? And specifically, I'm concerned about the differentiation between sensitive and private, but more importantly, what kind of obligations are there to maintain the privacy of the consumer, and what's the Privacy Commissioner's role to ensure that that's being done?
Yeah, so the entire regime is overseen by the Privacy Commissioner and has considerable capacities such as order-making powers and recommendations of AMPS, the ability to enter into consent agreements to modify the behavior of those who potentially violate the privacy of Canadians. All of this is interpreted within the broad category of a fundamental right to privacy, which was inserted at the preamble as well as at the outset of the bill. And the personal information kinds of use cases that we've talked about today would be governed by strict obligations for the use of personal information, notwithstanding the fact that it's not sensitive. So a company would need to be plain language clear at the point of collection for what the uses of the information were and what the individual could likely expect for the ongoing transfer of that information. They'd need to have a privacy program in place that would include the safety and security of the information in its disclosures. Those obligations would pass on to a disclosed entity. So if a disclosed entity is a payment processor in this particular use case, they inherit, notwithstanding the fact that it doesn't obviate the accountability of the original collector, they are required to continue to ensure that the trust and security of the information that's in their possession, notwithstanding the fact that it was transferred to them not without express consent. And so each step in that value chain is still governed by an overall approach that ensures that the continued privacy of Canadians remains fundamental in the overall transaction and in the collection, use, and disclosure of the information.
And you mentioned earlier that by stipulating
thank you, Mr. Van Bynen. I'm sorry, we'll get back to you when we come back on C27. We've reached the end of our meeting, and but I appreciate, members, your cooperation for this meeting. Merci à tous, merci aux témoins.
Thank you to everyone, our witnesses. We are adjourned.